following recording is of an interview conducted with former Illinois Appellate Court Judge Don Rizzi. After serving as judge, Mr. Rizzi retired and currently serves as a consultant for antitrust cases at a downtown Chicago law firm. The interview begins with Mr. Rizzi describing the work he does currently.
I retired from the appellate court in
Yeah.
1996. It's a long time ago.
Mm-hmm.
And you know what I do here? I'm on counsel with this firm.
Mm-hmm.
But they do antitrust work.
Yeah.
So it's been a long time since I've been away from criminal stuff. But okay, but I'll try to answer any questions.
Can you give us a little bit about your background in law and how you came to be practicing in law and a judge?
How I became a judge, is that what you want to know?
Yeah.
Practicing? Okay, so when I got out of law school, I got a job with, I graduated near the top of my class, and so when I got out of school, I probably ended up getting one of the best jobs of any of the graduating class. I got to work with a lawyer named James A. Dooley, D-O-O-L-E-Y. He was probably the most prominent trial lawyer in the country at the time. He's now deceased. And in 1976, he decided to run for the Supreme Court. He had no judicial background and really no political background, but he had a lot of money and he had a very big ego. He felt that he could run for the Supreme Court. So he ran for the Supreme Court, and I maintained my relationship with him all the years from the time I got a job with him when I left law school. And I became treasurer of his campaign. And neither one of us was ever involved in politics. But he won the primary election, and in the Democratic primary election, it was very unexpected. The only reason why he won because there was an incident in the Chicago area. Are you familiar with the Black Panther incident in Chicago?
Mm-hmm.
Where Mark, what's his name, was killed. Can't think of his name. But there are two members of the Black Panther were killed. And the person that was slated by the Democratic Party for that Supreme Court vacancy was the judge who was hearing the case, and he was entering some orders favoring Ed Hanrahan, who was the state's attorney, that's who they were going after, and so it was an unusual circumstance. But as a result, at any rate, the African American community these were different times then. The African American community became incensed with what had happened in connection with the Black Panther killings, and they voted heavily in favor of Dooley, who was running as an independent against the Democratic Party slated candidate, and so he ended up winning the election mainly for that reason. And so he then became a Supreme Court judge in 1976, and as a friend because I was a friend of his, he appointed me a judge. That's how the system works in Illinois and in Cook County. The Supreme Court judges appoint someone to fill a vacancy, and they rotate terms, and it was his turn, and so he selected me. And he appointed me a circuit court judge. And then I was a circuit court judge for maybe 13 months or so. And Dooley got me slated for the appellate court. And then I went on the appellate court in 1978, and he died in 1978. Dooley did March 6, 1978, he died, so I remained on the appellate court. That's how I became an appellate court judge.
Had you had any desire to become a judge prior to that?
Not until the time that Dooley became a Supreme Court judge and called me and said that there's a vacancy, and it's his turn to appoint someone, and so he appointed me. Up until then, I had no intention of becoming a judge.
And did you enjoy your time sitting as a judge?
It's a great experience. It's a wonderful experience.
What made it so great?
Just the nature of the job. It was a great, especially in the appellate court. It's a wonderful job. And it gave you an opportunity to do something good in terms of good for public. There's a public good there that you can do as an appellate court judge or any reviewing court judge.
So we know that one of the cases that you worked with was the Dualaby case. Can you explain your experience with that case?
My experience in how it came about, how we got our decision?
Mm-hmm.
Is that what you're talking
about? Yeah.
The Dualaby case got a lot of news attention because once the story got out that this little girl was killed and the manner in which she was killed, the public wanted to find the killer, and they put a lot of pressure on the state's attorney's office at the time, and Mayor Daley, Richard M. Daley was the state's attorney at the time, and he was getting a lot of flack to make sure that we find who did it, and they ended up charging the parents of the girl with murder, mother and father, and when I was on the appellate court reviewing the evidence in the record, it didn't appear that they ever proved either one of them guilty, the mother or the father. And the trial court judge was a very good judge. He's actually a friend of mine, but he made what I thought was a serious mistake, because the mother and the father were being tried at the same time for killing this little girl, their daughter, and they were in the house together, the three of them, before she was kidnapped or whatever and killed. So at the end of the evidence, the trial court judge granted what they call a directed verdict in favor of the mother, so that in other words, she's innocent. That's what the judge ruled, and he let the case go to the jury as to the father. Well, that really didn't make too much sense in my mind, because either they were both innocent or they were both guilty, because they put the child together the night before when she went to bed in her room. The next morning when they got up, she was gone. So if anybody was going to be guilty, they'd either both be guilty or both not be guilty, unless there was evidence or circumstances to show something otherwise, and there was none in this case. And so that was the first mistake that was made in the case, in my opinion, by entering what they call a directed verdict in favor of the mother and letting the case go to the jury as to the father. And then the case, the evidence in the case to prove him guilty just wasn't there. And so we never concluded one way or the other as to whether we felt the father was the perpetrator, but we were sure that the state didn't prove him guilty. That was the point. There wasn't enough evidence by the state to find him guilty. They had in the case. Want me to tell you the facts a little bit about this? The facts in the case or not? It's up to you.
Yeah, go ahead. We love that.
Well, my recollection is that the only evidence that they had, what the state called evidence, was that at 2 o'clock in the morning, in an area not too far from where the girl lived, there was a big apartment building, and the back of the apartment building was a big parking lot where tenants parked their car. So one of the tenants in the building parked his car in that parking lot at around 2 a.m. in the morning. And it was kind of a dark area. There were some lights, but it was a dark area. And he told the police officers that he saw a car when he parked his car around 2 o'clock in the morning or 1 o'clock in the morning, something like that. He saw a car about 70, I think 75, 70, it was almost the length of a football field, pulling out of a parking spot and driving away. And when the car pulled out, he saw a profile of the driver, and the man he told the police officer, had a large nose. And the car drove off. And then that witness told the police officers that he described the car. I think it was a blue car. Okay, so he told the police officers that story. So the police officers then showed that witness photographs, like a lineup photographs, and there maybe 5 or 6 photographs, and they were all police officers except for Mr. DeWalby. He was in that array of photographs. And this witness said that that person, which he pointed to a photograph of DeWalby, his nose resembled the nose of the man that he saw, which was, I don't know, I forget how far it was. My recollection is it might have been the length of a football field, I'm not sure. He says that nose resembled the man that he saw. But part of the problem was they only showed this witness frontal face photographs, no profile. So he only saw a profile of a man. And now he's looking only at a frontal face picture of these people. And he said that person somehow resembled he had a large nose that resembled the noses that this man that he saw drive out. And the person he pointed to was DeWalby. And let's see. And the car that he described, this was a blue car, and it turned out that DeWalby's had a car that might have been similar to the way he described the car in his testimony to the police officers. Not his testimony, but his statement to the police officers. That was the only evidence that they had against Mr. DeWalby. And the witness also said he did not know if the man that he saw was white or black or Hispanic. He didn't know that. He couldn't give you any other description of the man, other than the fact that he had a large nose. But he saw a profile, and he was looking at frontal pictures only. And those were the statements that were given to the police by that witness. At trial, that witness was presented. But at trial, he never said at trial, in his testimony as a trial witness, that DeWalby's nose resembled the nose of the man that he saw. It was the statements that he made to the police officers earlier. And that was the only evidence they had against Mr. DeWalby. As far as my recollection now is, that's all I recall, the only evidence they had against him. Well, you can't send a man to prison for, I think he got 40 years, I'm not sure. You can't send a man to prison if that's the only evidence that you have that he committed this crime. It just didn't make any sense. So the